I was halfway through building a snowman with my 6-year-old daughter Emma, when Brenda Whitmore came marching across my front lawn like she owned the place, clutching a clipboard and wearing an expression that could curdle milk. It was January 15th, 2026, and Winter Haven, Colorado had just been blessed with 18 inches of fresh powder overnight. Emma and I had spent the entire Saturday morning constructing an elaborate snow fort complete with towers, walls, and even a little tunnel system. My daughter's laughter had been echoing through the neighborhood all morning, and I honestly couldn't remember the last time I'd felt this happy since my divorce finalized 6 months ago. "Excuse me, Mr. Patterson." Brenda's nasally voice cut through the crisp winter air like a chainsaw. "I need to speak with you immediately about this unauthorized structure on your property." I wiped snow off my gloves and stood up, towering over her 5'3" frame. "Brenda, it's a snow fort. My daughter and I are just having some fun on a Saturday." Emma peeked out from behind one of the towers, her rosy cheeks and bright eyes suddenly clouded with confusion. She'd only met Brenda once before, during a brief encounter at the neighborhood mailboxes, but apparently that was enough for my daughter to recognize trouble when she saw it. According to Section 7, Subsection D of the Pinecrest Meadows Homeowners Association covenants, conditions, and restrictions, no temporary or permanent structures may be erected on any residential lot without prior written approval from the Architectural Review Committee. Brenda recited without even looking at her clipboard. She'd clearly memorized this particular passage. This includes but is not limited to sheds, gazebos, playhouses, and any other freestanding construction. I felt my jaw tighten. "It's made of snow. It'll be gone in a week when the temperature rises." "The material composition is irrelevant," she snapped back. "A structure is a structure. You have until 5 p.m. today to remove it, or you'll be subject to fines as outlined in Section 12 of the Enforcement Procedures. First violation is $500, and the fine doubles each day the violation continues." Emma's bottom lip started trembling, and I saw tears forming in her eyes. That sealed it for me. No way was I letting this power-hungry busybody ruin my daughter's day over a pile of snow. "Brenda, with all due respect, this is ridiculous. We're talking about something my kid built in the snow. I'm not tearing it down." Her eyes narrowed behind her thick framed glasses. "Then you'll be hearing from the HOA board. Have a good day, Mr. Patterson." She spun on her heel and marched back across my lawn, leaving deep footprints in the pristine snow. Emma tugged on my coat sleeve. "Daddy, do we have to break our fort?" I knelt down and hugged her tight. "No, sweetheart, we don't. Mrs. Whitmore is just being a grump. Let's finish our snowman, okay?" We spent the rest of the afternoon building and playing, but the joy had been tainted. I kept glancing toward Brenda's house 3 doors down, watching her silhouette pass back and forth behind her curtains. She was probably documenting everything, taking photos, building her case. The woman had been elected HOA president 8 months ago and had immediately begun a campaign of enforcement that made the previous administration look downright libertarian. Monday morning arrived with a letter in my mailbox. Not just any letter, but a formal notice of violation printed on official Pinecrest Meadows HOA letterhead. I stood at the end of my driveway in my work clothes, reading the document with increasing disbelief. "Dear Mr. Patterson, this letter serves as formal notification that your property at 2847 Snowbird Lane is in violation of the Pinecrest Meadows HOA-CC and Articus. On January 15, 2026, an unauthorized structure was erected on your front lawn without approval from the Architectural Review Committee. You have been assessed a fine of $500, payable within 15 days. Failure to remove the structure will result in additional daily fines of $1,000 per day, compounding until compliance is achieved or legal action is taken. Sincerely, Brenda Whitmore, HOA President. $1,000 per day. My hands actually shook as I read those words. The snow fort was still standing, though Emma and I hadn't added to it since Saturday. The weather had been cold enough to preserve it, and honestly, I'd been too angry to even think about dismantling it. I called my office and told them I'd be late, then immediately started searching for lawyers on my phone. This was insane. This was beyond insane. But I'd bought my house in Pinecrest Meadows 3 years ago, back when my marriage was still intact, and we'd thought the HOA was just a minor inconvenience that handled lawn care standards and pool maintenance. I'd signed the papers, including something about the CC and Articus, though I'd barely glanced at them during the chaos of closing. The first 3 law offices I called either didn't handle HOA disputes or wanted retainers that made my eyes water. The 4th call connected me to Mitchell and Associates, a small firm in downtown Denver, about 40 minutes from Winter Haven. Mitchell and Associates, this is Sarah speaking. Hi, my name is David Patterson. I need to speak with someone about an HOA issue. It's kind of urgent. One moment, please. Elevator music played for 30 seconds before a deep, gravelly voice came on the line. This is Robert Mitchell. Sarah says you've got HOA troubles. I explained the situation as concisely as I could, from the snow fort to Brenda's threats to the letter threatening $1,000 per day in fines. I probably sounded half crazy, but Mitchell listened without interrupting. Mr. Patterson, first question. Do you have copies of the CC and Articus you signed when you bought the house? I think so. They should be in my closing documents somewhere. Find them. Second question. Did you receive any other HOA documents when you moved in? Bylaws, amendments, anything like that? I got a welcome packet with pool hours and trash pickup schedules. That's about it. Mitchell was quiet for a moment. Here's what I want you to do. Don't pay anything yet. Don't respond to their letter. Dig up every piece of paper you have related to the HOA and bring it to my office. Can you come by tomorrow morning, say 10 a.m.? Yes, absolutely. How much is this going to cost me? Initial consultation is free. If I take your case, we'll discuss fees then. But Mr. Patterson, I'm going to be straight with you. HOA cases can get expensive and messy. Sometimes it's cheaper to just comply and move on. They want to fine me $1,000 a day over a snow fort my daughter built. Point taken. See you tomorrow at 10. That evening, after putting Emma to bed at my ex-wife's place, she had primary custody, and I got Emma on weekends and some weekday evenings. I spent 3 hours digging through boxes in my garage. I finally found the accordion folder from my house closing, stuffed with more paper than I remembered. The mortgage documents, insurance policies, inspection reports, and buried near the bottom, a thick booklet titled Pinecrest Meadows Declaration of Covenants, Conditions, and Restrictions. I made coffee and started reading. It was every bit as dry and bureaucratic as I'd expected. Page after page of rules about fence heights, paint colors, landscaping requirements, vehicle parking, and yes, there it was on page 47. Section 7, subsection D. No structure, temporary or permanent, shall be placed, erected, or maintained on any lot without prior written approval of the Architectural Review Committee. The language was exactly as Brenda had quoted. I kept reading, looking for anything that might help me. Section 12 outlined the enforcement procedures and fine structure. First violation was $500, subsequent violations doubled each day. It was all there in black and white, signed and dated from 1998 when the development was first created. I barely slept that night. The snow fort was still standing when I left for Denver the next morning, and I half expected to find another letter in my mailbox. Sure enough, there it was. Second notice. As of January 18, 2026, the violation at 2847 Snowbird Lane continues. Your account has been assessed an additional $1,000 fine. Total amount due, $1,500. Tomorrow's fine will be $2,000 if the structure remains. My stomach churned. I was a project manager for a software company, made decent money, but I wasn't made of cash. $1,500 was my car payment and grocery budget combined. If this kept compounding, I'd be bankrupt in a week. Mitchell and Associates occupied a modest second-floor office in a renovated brick building near Denver's Capitol Hill neighborhood. Robert Mitchell turned out to be a barrel-chested man in his late 50s with steel-gray hair, and the kind of handshake that conveyed both competence and aggression. His office walls were covered with framed law degrees, bar certifications, and what looked like newspaper clippings about various cases. "Mr. Patterson, good to meet you in person. You bring the documents." I handed over the accordion folder, along with the 2 violation notices. Mitchell sat behind his desk and started going through everything methodically, making notes on a legal pad. He spent particular attention on the CC and Articus booklet, flipping through pages and occasionally grunting. "Tell me about this Brenda Whitmore," he said without looking up. "She's been HOA president for about 8 months. Before her, the association was pretty laid back. We'd get the occasional notice about leaving trash cans out too long, but nothing serious. Brenda came in promising to restore standards and property values. Since then, she's been on a rampage. My neighbor got fined because his mailbox was the wrong shade of black. Another guy got hit with violations because his Christmas lights stayed up until January 7th. Mitchell nodded, still reading. She got elected or appointed. Elected. There was a special meeting last May. Honestly, most people didn't show up. I didn't. She won with like 30 votes in a neighborhood of 200 homes. Classic. Mitchell set down the CC and Articus and leaned back in his chair. "Here's what I'm seeing, Mr. Patterson. Yes, there's language in these covenants that technically prohibits structures without approval. However, the interpretation of that language is questionable when applied to something like a snow fort. Courts generally require reasonableness in HOA enforcement, and you could argue that a temporary snow structure clearly meant for child's play falls outside the intended scope of architectural review. So I have a case, maybe. But here's the thing. Even if we fight this and win, you're looking at legal fees that could exceed the fines. HOA litigation is expensive because these associations often have deep pockets from member dues, and they can be incredibly stubborn." My heart sank. "So I should just tear down my kid's snow fort and pay them $1,500. Mitchell held up a finger. "I didn't say that. I said maybe, because there's something else I want to check first." He tapped the CC and Articus booklet. "These covenants, they need to be properly recorded with the county to be enforceable. That means filed with the county clerk and recorder's office. When you bought your house, the title company should have noted any recorded restrictions as part of your title search." "Okay. I want to pull the property records for your house and for the Pinecrest Meadows subdivision. If these CC and Articus were never properly recorded, or if there's some defect in how they were filed, then they might not be legally enforceable at all." A small flame of hope flickered in my chest. "How long does that take? I can do a preliminary search this afternoon. Give me 48 hours to dig deeper. In the meantime, don't tear down the snow fort and don't pay any fines. Let them keep sending letters." They're saying the fines double every day. Let them say it. If they're not legally entitled to fine you in the first place, it doesn't matter if they claim you owe $10 or $10 million. You still owe nothing. I left Mitchell's office feeling a strange mixture of hope and dread. The drive back to Winter Haven seemed longer than usual, traffic crawling on I-25. I kept checking my phone at red lights, half expecting Mitchell to call with bad news. When I finally pulled into my driveway around 2 p.m., the snow fort was still standing, though it had started to sag a bit in the afternoon sun. My neighbor Tom waved from his driveway. He was retired, spent most days tinkering with his vintage motorcycle collection. "Hey Dave, heard you're in trouble with the HOA. Word traveled fast in Pinecrest Meadows. Yeah, apparently Emma's snow fort is a threat to property values." Tom snorted. "Brenda's got to stick up her rear end the size of a telephone pole. You know she tried to fine me last month because I had my garage door open while I was working on a bike. Said it was unsightly. I told her where she could stick her fine. Did she back down? Eventually. I think she picks her battles. Figured you'd be an easier target since you're newer to the neighborhood and going through the divorce and all." Tom's expression softened. "That's rough, man. How's Emma handling everything?" "She's okay. Loves building stuff in the snow. That's why I'm not backing down on this." "Good for you. Let me know if you need anything. Half the neighborhood is sick of Brenda's power trip." That night I got another letter. This one wasn't in my mailbox. It was taped to my front door. Third notice. As of January 19, 2026, the violation continues. Additional fine of $2,000 assessed. Total amount due, $3,500. Be advised that continued non-compliance may result in legal action including property liens and foreclosure procedures. Foreclosure. My hands clenched around the paper. They were threatening to take my house over a snow fort. I took a photo of the letter and texted it to Mitchell. He responded within 5 minutes. "Don't panic. Empty threats. Keep documenting everything." Wednesday crawled by at work. I couldn't concentrate on the software deployment I was supposed to be managing. My phone sat on my desk, volume turned up, waiting for Mitchell's call. It finally came at 4:30 just as I was pretending to review code specifications. "Mr. Patterson, Robert Mitchell. You're going to want to sit down for this." My pulse quickened. "Good news or bad news?" "Potentially very good news." I pulled the records for Pinecrest Meadows from the Adams County Clerk and Recorder's office. The subdivision was platted and recorded in 1998. However, the declaration of covenants, conditions, and restrictions that you have, the ones Brenda is trying to enforce, they were never properly recorded. What does that mean? It means they might not be legally binding. When a developer creates an HOA, they need to record the CC and Articas with the county as part of the plat documents. That recording gives notice to all future property owners that these restrictions exist. If the CC and Articas aren't recorded, they generally can't be enforced against people who weren't original buyers. I bought my house in 2023 from the previous owners. I wasn't an original buyer. Exactly. Now, here's where it gets interesting. I found some paperwork showing that the developer, a company called Westridge Development LLC, filed a basic plat map and some utility easements in '98. But there's no recorded CC and Articas attached to any of the Pinecrest Meadows filings. Not in '98, not ever. So Brenda's been enforcing rules that don't legally exist. That's what I need to verify. The HOA might argue that the CC and Articas were recorded somewhere else, or that they're binding through some other mechanism. I need to do more digging, talk to the county recorder's office directly, maybe track down the original developer's records. But Mr. Patterson, If I'm right about this, you don't just have a defense against these fines. You might have grounds to challenge the entire HOA's authority. I felt lightheaded. How much is this going to cost me? For the research and initial legal work, I'd estimate $3,000 to $5,000. If this goes to court, more. But here's the thing. If we can prove the CC and Articus were never properly recorded, you might be able to recover your legal fees from the HOA. Plus, once word gets out, you won't be the only homeowner interested in this information. I'd bet money half your neighborhood would chip in to see this through. $3,000 to $5,000 was still a lot of money, but it was less than the fines were already threatening to become. Do it. Whatever you need to do, do it. I'll need a retainer. $2,500 to start. I'll bill against that for my time and expenses. I swallowed hard. I can have that to you by Friday. Perfect. And Mr. Patterson, don't tear down that snow fort. In fact, if your daughter wants to make it bigger, go right ahead. Thursday morning brought another letter, this time delivered by certified mail. The postal carrier made me sign for it, gave me a sympathetic look, and hurried back to her truck. The envelope was thicker this time. Fourth notice and final warning. As of January 20, 2026, the violation continues. Additional fine of $4,000 assessed. Total amount due, $7,500. This letter serves as formal notice of the HOA board's intent to place a lien on the property at 2847 Snowbird Lane, and to initiate foreclosure proceedings if the violation is not cured and all fines paid within 7 days. Additionally, the board has voted to pursue legal action to obtain injunctive relief and may seek attorney fees and court costs. $7,500. In less than a week. Over a snow fort. I photographed the letter and sent it to Mitchell, then forwarded a wire transfer for his retainer. My savings account, already diminished from the divorce, took a painful hit. But I was committed now. This had gone from being about a snow fort to being about principle. Mitchell called me that afternoon. Got your retainer, thank you. I'm making progress on the research. I spoke with the county recorder's office this morning. They confirmed there's no recorded CC and Articus for Pinecrest Meadows in their system. They did a comprehensive search going back to 1995. Nothing. I also tracked down Westridge Development's corporate records. The company dissolved in 2003, which might explain why nobody caught this earlier. So what's our next move? I'm drafting a formal response to the HOA, asserting that their CC and Articus are unenforceable and demanding they cease all collection efforts. I'll cite the lack of recorded covenants and argue that they have no legal authority to levy fines. That should get their attention. Will they back down? Probably not immediately. They'll likely respond with threats of their own. But here's what I'm hoping. Once we force them to actually prove their authority in court, they'll realize they can't. Most HOAs rely on homeowners not fighting back. When someone does fight back and has a legitimate legal argument, things get interesting. Friday evening, I had Emma for the weekend. We drove to my place from her mother's house in Boulder, Emma chattering about school and her friends and a new book she was reading. When we pulled into the driveway, she immediately noticed the snow fort. Daddy, it's still here. Of course it is, sweetie. Did you think I'd tear it down? Mom said the HOA lady was being mean to you about it. I made a mental note to talk to my ex-wife about discussing adult problems in front of Emma. Mrs. Whitmore doesn't understand how important snow forts are. But don't worry, I'm handling it. We spent Saturday morning reinforcing the fort and adding a new tower. The weather had stayed cold, and Friday night brought another 4 inches of fresh powder. Emma was delighted. We were packing snow for the tower's base when I noticed a car slow down in front of my house. A sedan with tinted windows. It stopped for about 30 seconds, then drove on. 10 minutes later, it came back from the other direction, stopped again. I couldn't see who was inside, but I had a pretty good idea. "Emma, honey, go inside and warm up for a minute. Get some hot chocolate." "But we're not done with the tower." "I know, I just need to make a quick phone call." 5 minutes, okay, she trudged inside, tracking snow through the house. I pulled out my phone and called Mitchell's office, got his voicemail, left a message about the car. I was probably being paranoid, but something felt off. The car came back a third time an hour later. This time it parked across the street, and a woman got out with a professional camera. She walked onto my lawn and started taking photos of the snow fort from multiple angles. I recognized her, one of Brenda's friends from the HOA board, Linda something. "Can I help you?" I called out from my front door. Linda jumped, startled. "Just documenting the ongoing violation for the board's records. You're on my property without permission. The HOA has a right to document violations." "No, you have a right to view my property from public areas. You don't have a right to walk on my lawn. Please leave." Linda's mouth pressed into a thin line, but she retreated to the sidewalk and took a few more photos from there before getting back in her car and driving away. I made notes about the encounter, including the time and date, and emailed them to Mitchell. His response came Sunday afternoon. "Good job documenting. They're building a case, which means they're taking you seriously. That's actually good for us. The more aggressive they get, the more likely they are to make mistakes." Monday morning, I found a new letter in my mailbox. But this one wasn't from the HOA. It was from a law firm, Blackstone and Reed, attorneys at law based in Denver. "Dear Mr. Patterson, this firm has been retained by the Pinecrest Meadows Homeowners Association to pursue collection of outstanding fines and to seek injunctive relief regarding ongoing violations at your property. You currently owe the association $15,500 in assessed fines. If this amount is not paid in full within 5 days, we will file a lawsuit in Adams County District Court seeking judgment, property lien, foreclosure rights, injunctive relief, attorney fees, and court costs. We strongly advise you to resolve this matter immediately to avoid further legal action. $15,500. The number had grown beyond obscene into the realm of surreal. I'd been documenting every letter, every fine, every escalation, and watching the total balloon into something that could destroy me financially. I forwarded the letter to Mitchell and waited for his call. It came within an hour. They hired Blackstone and Reed. Interesting choice. Is that good or bad? It's a mid-sized firm that does a lot of HOA work. They're competent, which means they won't make stupid mistakes, but they're also expensive. The HOA is spending serious money on this, which tells me two things. First, Brenda Whitmore is absolutely committed to making an example of you. Second, they either don't know about the CC&R recording problem or they think they can bluff their way through it. What do we do? I respond to their letter with our own. I'll lay out our position. The CC&R tickets were never properly recorded, therefore the HOA lacks authority to enforce them, therefore all fines are invalid. I'll also make a formal demand that they cease collection efforts and remove any reference to these supposed fines from your HOA account. If they want to fight about it, we'll fight in court. And if they do file a lawsuit, then we file a motion to dismiss based on lack of standing. We force them to prove they have the legal authority to do what they're doing. Mr. Patterson, I've been practicing law for 26 years. I've seen a lot of HOA cases. If I'm right about the recording issue, this is one of the strongest defenses I've ever come across. These people have no leg to stand on. Mitchell's confidence was reassuring, but I still spent Monday night barely sleeping. The snow fort outside was starting to show its age, melting and refreezing into something more ice than snow. Emma wouldn't be back until next weekend, and part of me wondered if I should just tear the thing down and end this nightmare. But that would mean Brenda won. It would mean letting her bully me into submission. And more than that, it would mean teaching Emma that standing up for yourself wasn't worth the trouble. Tuesday brought another letter from Blackstone and Reid, this one in response to whatever Mitchell had sent them. The tone had shifted from threatening to coldly professional. Mr. Patterson, we are in receipt of correspondence from your attorney, Mr. Robert Mitchell, dated January 24, 2026. While we acknowledge his assertions regarding the recorded status of the Pinecrest Meadows CC and Articus, we maintain that these covenants are binding on all homeowners through multiple legal mechanisms, including incorporation by reference in property deeds, implied acceptance through purchase and residency, and established community practice. The fines assessed against you are valid and enforceable. Your account balance now stands at $19,500. We await your payment. $19,500. I had to read it 3 times to make sure I wasn't hallucinating. They'd added another $4,000 increment. At this rate, I'd owe more than my annual salary by the end of the month. Mitchell called me that evening. I got a copy of Blackstone and Reid's response. Their arguments are creative, I'll give them that. Incorporation by reference, implied acceptance. These are legitimate legal theories in some contexts, but they don't overcome the fundamental problem. Colorado law requires CC and Articus to be recorded to be enforceable against subsequent purchasers. There are exceptions, but they're narrow and don't apply here. So what happens now? Now we wait. If they're smart, they'll realize they're overextended and offer to settle. You withdraw your challenge to their authority, they withdraw all the fines, everybody goes home. If they're not smart, they'll file the lawsuit and we go to court. Which do you think they'll do? Mitchell sighed. Honestly, I think Brenda Whitmore's pride won't let her back down. She's made this into a personal crusade. Even if her lawyer tells her the case is weak, she'll push to fight it. We should prepare for litigation. The lawsuit was filed on January 28th. I received the summons and complaint via certified mail on January 30th. The document was 23 pages long, filled with legal jargon and numbered paragraphs. The gist was simple. The HOA wanted a court order forcing me to pay $19,500, plus interest, attorney fees, and court costs. They also wanted an injunction requiring me to remove the snow fort immediately and prohibiting any future violations. Reading through the complaint, I noticed they'd attached what they claimed was a copy of the recorded CC and Articus. Mitchell had told me to watch for this. I scanned the document carefully. There was no recording stamp, no county clerk endorsement, no book and page number indicating where and when it had been filed. It was just a clean photocopy of the same booklet I had. I sent everything to Mitchell, who called me that evening. This is good. They attached an unrecorded document and claimed it was recorded. That's sloppy. I'll file our answer and counterclaim within the deadline, probably next week. In the meantime, they're going to try to get a preliminary injunction hearing scheduled quickly. That's when a judge decides if there's enough evidence to order you to tear down the snow fort before the full trial. When would that be? Probably 2 to 3 weeks. Colorado courts move pretty fast on injunction requests. You should plan to attend the hearing and be prepared to testify if needed. The next 2 weeks were a blur of work, parenting time with Emma, and constant communication with Mitchell. He filed a comprehensive answer to the lawsuit. denying all of the HOA's claims and asserting that they lacked authority to enforce unrecorded covenants. He also filed a counterclaim seeking a declaratory judgment that the CC and Articus were invalid, plus compensation for my attorney fees and emotional distress. The preliminary injunction hearing was set for February 17th at 9 a.m. in Adams County District Court. The night before, Mitchell and I met at his office to prepare. "Here's how this will work," he explained, spreading documents across his conference table. "The HOA has to prove 4 things to get an injunction: likelihood of success on the merits, irreparable harm, balance of hardships, and public interest. We'll attack each element, but our main argument is simple. They can't prove likelihood of success because their CC and Articus were never recorded." "What do I need to do?" "Just answer questions honestly if the judge asks you anything. Don't volunteer information. Keep your cool, even if Brenda or her lawyer say something that pisses you off. Judges hate drama." The courtroom was smaller than I'd imagined, nothing like the grand spaces you see in movies. Wood paneling, fluorescent lights, and uncomfortable benches. Mitchell and I sat at the defendant's table. Across the aisle, 2 lawyers from Blackstone and Reed sat with Brenda Whitmore, who wore a severe gray suit and her trademark scowl. Judge Margaret Kowalski presided, a woman in her 60s with sharp eyes and an air of no-nonsense efficiency. She took the bench exactly at 9 a.m. and got straight to business. "This is case number 2026, CV 1837, Pinecrest Meadows Homeowners Association versus David Patterson. We're here on plaintiff's motion for preliminary injunction. Counselors, we have a lot on the docket today, so let's keep this tight. Plaintiff, you may proceed." The lead attorney for Blackstone and Reed was a smooth-talking man named Gerard Simmons. He stood and launched into his argument about how the snow fort violated clearly established HOA rules, how my continued defiance was undermining the association's authority, and how allowing the structure to remain would cause irreparable harm to property values and community standards. "Your Honor," Simmons said, "this is not about a simple snow fort. It's about a homeowner's willful refusal to comply with covenants he agreed to when he purchased his property. If Mr. Patterson is allowed to ignore these rules with impunity, it sets a precedent that will erode the entire HOA structure. Every homeowner will feel emboldened to violate the CC and Articus, and property values will plummet." Judge Kowalski listened impassively, taking notes. When Simmons finished, she turned to Mitchell. "Mr. Mitchell, your response." Mitchell stood, and I was struck by how calm he seemed. "Your Honor, there's a fundamental threshold problem with this entire case. The plaintiff lacks standing to enforce these CC and Articus because they were never properly recorded with Adams County. Under Colorado law, specifically CRS. Section 3833.3106, restrictive covenants must be recorded to be enforceable against subsequent purchasers. Mr. Patterson bought his home in 2023, long after the subdivision was created. He's entitled to rely on the county records, which contain no recorded CC and Articus for Pinecrest Meadows." Simmons jumped up. "Your Honor, the CC and Articus were incorporated by reference in Mr. Patterson's deed. He had constructive notice." Mitchell shook his head. "May I respond, Your Honor?" Briefly. "The deed contains boilerplate language about covenants of record, but there are no covenants of record. You can't incorporate something by reference if that something doesn't exist in the public record. We've done an exhaustive search. The Adams County Clerk has confirmed there are no recorded CC and Articus for this subdivision." Judge Kowalski leaned forward. "Mr. Simmons, Do you have evidence that these CC and RTCS were recorded? A book and page number, a reception number, anything from the county? Simmons flipped through his papers. Your Honor, we have a copy of the CC and RTCS, which were created when the subdivision was platted in 1998. That's not what I asked. Were they recorded with the county? The HOA has maintained and enforced these CC and RTCS for over 25 years, Your Honor. They've been treated as binding by hundreds of homeowners. That establishes their validity. That establishes practice, not legal validity. Mr. Simmons, I'm going to give you 1 week to provide documentary proof that these CC and RTCS were properly recorded. If you can't provide that proof, I'm denying your motion for preliminary injunction, and we're going to have a serious conversation about whether this case should proceed at all. Brenda Whitmore made a strangled sound. Simmons put a hand on her arm, silencing her. Your Honor, we request a brief recess to consult with our client. 10 minutes. The judge left the bench. Mitchell leaned over to me. This is going better than I expected. She sees the problem. I watched Brenda and her lawyers huddle in the hallway outside the courtroom. Through the glass doors, I could see Brenda gesticulating wildly, her face red. Simmons appeared to be trying to calm her down. The other Blackstone and Reed lawyer was on his phone, presumably calling someone. When court resumed, Simmons looked less confident. Your Honor, the HOA requests a continuance of 1 week to gather additional documentation regarding the recording of the CC and RTCS. Granted. We'll reconvene on February 24th, same time. Mr. Simmons, understand that if you cannot provide clear evidence of recording, I will not only deny your injunction, I'm going to seriously consider sanctions for bringing a claim without proper foundation. This court's time is valuable. The gavel came down. Mitchell gathered his papers, trying not to smile. Brenda stormed out of the courtroom without looking at us. As we walked to the parking garage, Mitchell finally let himself grin. That went about as well as it possibly could have. The judge basically told them their case is garbage. So what happens next week? One of 3 things. They produce evidence of recording, which I don't think exists. They drop the case entirely. Or they show up empty-handed and try to argue their way around it, in which case the judge dismisses and possibly hits them with sanctions. We were walking past my truck when a voice called out. Mr. Patterson, I turned. It was Linda, the woman who'd been photographing my property. She hurried over, glancing around nervously. I need to talk to you, not here, somewhere private. Mitchell stepped forward. I'm Mr. Patterson's attorney. Anything you want to say to him, you can say in front of me. Linda bit her lip. I'm on the HOA board, or I was. I resigned this morning after the hearing. Brenda has been lying to us. She told us the CC and RTCS were properly recorded, that we had every legal right to fine you. But after your lawyer raised the issue, I asked to see the recorded documents. She couldn't produce them. She kept making excuses, saying they were filed in 1998 and the records were old, that she'd get them eventually. But I went to the county myself yesterday. There's nothing. Mitchell pulled out a notepad. Are you willing to provide a sworn statement to that effect? Yes. I also want you to know that Brenda has been spending HOA funds on this lawsuit without proper board authorization. She told us it would cost maybe $2,000 or $3,000. We've already spent over $15,000 on Blackstone and Reed, and that's just in the last 3 weeks. My jaw dropped. $15,000 to fight over a snow fort. It's not about the snow fort anymore. Brenda's made it personal. She hates that you stood up to her. But here's the thing. About 5 years ago, there was an attempt to properly record the CC and RTCS. One of the previous board members hired a lawyer to research it. The lawyer found that the original developer had never recorded them, probably due to an oversight or cost cutting. The lawyer said we could record them retroactively, but it would require approval from a supermajority of homeowners, like 75%. The board tried to get that approval and failed. Most people didn't respond to the vote, and some explicitly voted no. The lawyer advised that without proper recording, enforcement would be risky. But Brenda wasn't on the board then, and when she took over, she either didn't know about that history or chose to ignore it. Mitchell was writing furiously. "Do you know who that lawyer was?" "A guy named Henderson." "James Henderson. He had an office in Westminster. Is there any documentation of his advice?" "There should be in the HOA records. Brenda has access to all of that." "Would you be willing to testify in court about what you just told me?" Linda nodded. "I'm done protecting Brenda. She's turned our neighborhood into a war zone, and people are miserable. Half the board wanted to drop your case last week, but Brenda overruled us and said she'd handle it personally." We got Linda's contact information and statement. Mitchell assured her he'd be in touch. As she walked away, he turned to me with a gleam in his eye. "This changes everything. If there's documentation that the HOA knew the CC and Articas weren't recorded and tried to fix it but failed, that's evidence of bad faith enforcement. We might be looking at fraud, breach of fiduciary duty, misappropriation of HOA funds. This could get very ugly for them." The next few days were intense. Mitchell subpoenaed the HOA's records, including all board meeting minutes, financial records, and correspondence with attorneys. Brenda tried to fight the subpoena, but Judge Kowalski ordered compliance within 48 hours. The documents arrived at Mitchell's office in 3 large boxes. We spent an entire Saturday going through them. Emma was with her mother that weekend, so I had nothing but time. Mitchell's paralegal, a sharp young woman named Jennifer, helped us organize and catalog everything. Around 2 p.m., Jennifer let out a low whistle. "Boss, you need to see this." She handed Mitchell a folder labeled Legal Consultation 2021. Inside were letters between the HOA board and James Henderson, the attorney Linda had mentioned. Mitchell read through them, his expression darkening. "Listen to this. This is from Henderson to the board, dated March 15, 2021. After thorough review of the Adams County records, I must advise that the Pinecrest Meadows CC and Articas were never recorded as required by Colorado statute. The subdivision plat was filed, but the accompanying declaration of covenants was not. This creates significant enforceability issues. While the CC and Articas may be binding on original purchasers who had actual notice, they are unlikely to be enforceable against subsequent purchasers who can legitimately claim lack of notice. I strongly recommend that the board pursue a formal ratification and recording process to cure this defect. Without proper recording, any attempt to enforce these covenants through fines or litigation carries substantial risk of adverse judgment and potential liability for wrongful collection efforts. I stared at the letter. They knew. Brenda knew. Maybe not Brenda personally, since this was before she was president, but the organization knew. And look at this. He pulled out another document, a memo dated June 2021. The board voted to pursue Henderson's recommended ratification process. They sent out a vote to all homeowners. I see the tally here. Only 42% responded, and of those, 61% voted yes. That's nowhere near the 75% threshold needed. Jennifer found another relevant document, an email chain from September 21. The board discussed their options after the failed ratification vote. One board member suggested ceasing enforcement until the issue could be resolved. Another suggested only enforcing the most basic rules on a voluntary compliance basis. The email chain ended with a note that the issue would be tabled until a new board was elected. They kicked the can down the road, Mitchell said. And then Brenda came in and either didn't review these records or decided to ignore them. Can we prove she saw these documents? We'll find out. I'm deposing her next week. The continued preliminary injunction hearing on February 24th was even more dramatic than the first session. Simmons from Blackstone and Reed stood before Judge Kowalski and admitted, in carefully parsed legal language, that his firm had been unable to locate evidence of recorded CC and Artiques in the Adams County records. However, Your Honor, he continued, we maintain that enforceability can be established through alternative means, including the doctrines of equitable servitude and implied reciprocal negative easements. Judge Kowalski was not impressed. Mr. Simmons, those doctrines have very specific requirements, including notice to subsequent purchasers. You're asking me to issue an injunction that would cost your opposing party money and restrict his use of his property. Based on legal theories you're essentially inventing on the fly. The answer is no. Your motion for preliminary injunction is denied. Brenda shot to her feet. Your Honor, this is outrageous. He's openly violating our community rules. The judge's gaze could have frozen lava. Madam, you will sit down and be quiet or I will hold you in contempt. Your lawyers speak for you in this courtroom. Brenda sat, her face purple with rage. Simmons looked like he wanted to disappear. Furthermore, Judge Kowalski continued, I've reviewed the materials submitted by the defense, including documents produced by the HOA showing that, as recently as 2021, the board was advised by counsel that these CC and Artiques are not properly recorded and therefore unenforceable. Mr. Simmons, did you know about these documents when you filed this lawsuit? Your Honor, our client provided us with the CC and Artiques and assured us they were valid and enforceable. We relied on that representation in good faith. So you didn't review the HOA's own records before filing suit? Simmons hesitated. We reviewed the materials provided by our client. That's not what I asked. Never mind. Here's what's going to happen. This case is proceeding to trial on the issue of whether the HOA has any legal authority to enforce these alleged covenants. Trial is set for April 7th. In the meantime, Mr. Patterson is free to maintain his snow fort or any other structure he deems appropriate on his property, and the HOA will cease all collection efforts related to the alleged fines. If I find out they've so much as sent him a threatening letter, I will sanction them severely. Are we clear? Yes, Your Honor, Mitchell said. Simmons nodded miserably. Yes, Your Honor. As we left the courtroom, I felt lighter than I had in weeks. The snow fort had mostly melted by this point, victim of rising February temperatures, but the principle remained. Mitchell clapped me on the shoulder. We're winning. They know it. Now it's just a matter of running out the clock to trial and getting a formal judgment. But things were about to get even more interesting. 2 days after the hearing, I received a phone call from a reporter at the Denver Post. Her name was Rachel Kim, and she'd somehow heard about the case. Mr. Patterson, I'm writing a story about HOA overreach and abuse of power. Your case has some interesting elements. Would you be willing to talk to me? I put her on speaker and called Mitchell. He advised me to cooperate but be cautious about what I said. The article ran on March 3rd, front page of the Metro section. HOA tried to fine homeowner $19,000 over snow fort, but their rules were never legally binding. Rachel Kim had done her homework. She'd interviewed Linda, the former board member who went on record about Brenda's deception. She'd gotten quotes from James Henderson, the attorney who'd advised the board in 2021. She'd even tracked down other Pinecrest Meadows residents who'd been subjected to questionable fines and enforcement actions. The article painted a damning picture of an HOA that had been functioning for decades based on covenants that were never properly recorded, racking up fines and threatening homeowners with no legal authority to do so. The headline was picked up by local news stations. By that evening, I'd received calls from 3 different TV reporters wanting interviews. Mitchell advised me to do one interview, so I chose a local station that promised to handle the story fairly. The segment aired on March 5th. They showed footage of what remained of Emma's snow fort, interviewed me about the escalating fines and legal battle, and included a clip of Brenda declining to comment but looking furious as she slammed her front door in the reporter's face. The publicity changed everything. Within days, I received emails from over 40 Pinecrest Meadows residents who'd paid fines over the years for various alleged violations. A class action lawsuit started to form. Mitchell connected these homeowners with another attorney who specialized in class actions, a woman named Teresa Cordova. The HOA board held an emergency meeting on March 10th. Linda forwarded me the minutes. Brenda had been removed as president by a unanimous vote of the remaining board members. The board voted to drop the lawsuit against me and to refund any fines I'd paid, which was zero since I'd never paid them a dime. Gerard Simmons from Blackstone and Reed filed a motion to dismiss the case on March 13th, noting that the parties had reached a settlement. Mitchell objected. "We don't have a settlement," he told me on the phone. "They want to dismiss and walk away, but you're entitled to your attorney fees, and frankly, I think you should push for more. They put you through hell over a snow fort. They threatened to take your house. They defamed you to your neighbors. There are damages here." We countered with a settlement demand. The HOA would pay my attorney fees, currently around $8,000, issue a formal apology, and agree to a consent decree acknowledging that their CC and Articus were unenforceable unless and until properly recorded. We also demanded that Brenda Whitmore be permanently barred from serving on the HOA board. The HOA's new president, a reasonable guy named Marcus Chen, who'd been part of the faction opposing Brenda's extremism, called me directly. "Mr. Patterson, I want to apologize on behalf of the board for everything you've been put through. Brenda acted without proper authority and misled us about the legal foundation for her enforcement actions. We're prepared to meet your settlement terms. We've also launched an internal review of all fines assessed over the past 2 years. Anyone who paid money based on CC and R violations is getting a refund." "What about Brenda?" "She's already resigned from the board, and we're considering whether to pursue legal action against her personally for misappropriation of HOA funds and breach of fiduciary duty. That's a separate matter, but I want you to know we're taking it seriously." The settlement was finalized on March 28th. The HOA paid my attorney fees and issued a community-wide letter acknowledging that their previous enforcement practices had been legally questionable. They announced a formal process to properly record the CC and Articus, which would require a homeowner vote. The letter made clear that until such recording occurred and was approved by the requisite supermajority, enforcement would be limited to issues required by law, such as health and safety violations. But the story wasn't quite over. In early April, I got a call from Detective Sarah Morrison with the Adams County Sheriff's Office. She wanted to talk to me about the HOA case. "Mr. Patterson, we've received complaints about possible criminal activity related to HOA funds. Your name came up as someone who might have relevant information. I met with Detective Morrison at the sheriff's substation in Commerce City. She explained that once the Denver Post article ran, several residents had filed complaints alleging that Brenda Whitmore had embezzled HOA funds. The subsequent investigation revealed that over the past 8 months, Brenda had authorized payments totaling nearly $60,000, far exceeding what the board had approved for routine expenses. "A lot of that money went to Blackstone and Reed for your case," Morrison explained. "But there are other questionable expenditures, payments to a landscaping company that doesn't appear to exist, reimbursements to herself for expenses that aren't documented. We're looking at possible theft, fraud, and embezzlement. What do you need from me?" "Just your testimony about what happened, the timeline of events, and copies of any documents you have. Your attorney already provided us with a lot of material." I gave Detective Morrison everything I had. Over the next few weeks, the investigation expanded. It turned out Brenda had been using HOA money for personal expenses, disguising them as community expenditures. She'd paid for her own home renovations using HOA funds, claiming they were for clubhouse repairs. She'd charged personal travel on the HOA credit card. On May 4th, Brenda Whitmore was arrested at her home and charged with theft, embezzlement, and fraud. The local news covered her perp walk, looking very different from the imperious HOA president who'd marched onto my lawn 4 months earlier. She looked small, frightened, and defeated. The criminal case proceeded through the system. Brenda initially tried to fight the charges, but the evidence was overwhelming. In July, she accepted a plea deal: restitution of $62,000 to the HOA, 3 years probation, and 500 hours of community service. She and her husband put their house up for sale and moved out of Pinecrest Meadows by August. As for me, life gradually returned to normal. The snow had long since melted, taking Emma's fort with it, but we'd taken plenty of photos. My daughter thought the whole thing was an adventure, her dad fighting the mean HOA lady and winning. I tried to frame it as a lesson about standing up for what's right, even when it's hard. The Pinecrest Meadows HOA underwent a complete transformation. Marcus Chen and the new board were reasonable people who understood that an HOA should serve the community, not terrorize it. They held a vote on whether to properly record the CC and Articus, and it failed. Turns out most residents liked the idea of living without binding covenants. The HOA continued to exist as a voluntary organization that maintained common areas and organized neighborhood events, but enforcement of rules became essentially non-existent. I became something of a local celebrity in HOA reform circles. Rachel Kim's article was picked up nationally, and I did interviews with several publications about HOA abuse and the importance of understanding property law. Mitchell used the case as a teaching example in continuing legal education seminars. The class action lawsuit on behalf of other Pinecrest Meadows residents who'd paid fines resulted in a settlement of $180,000, distributed among 73 families. It wasn't huge money for most people, a few hundred to a few $1,000s each, but it was vindication. I ran into Tom, my neighbor, at the community pool in late July. We were watching Emma and his grandkids splash around in the shallow end. "You did good, Dave," Tom said, nursing a beer. "You stood up to that witch when the rest of us were too tired or scared to fight. Neighborhood's better for it. I just wanted my daughter to be able to build a snow fort. It was never really about the snow fort, though, was it? It was about people like Brenda who get a little bit of power and use it to make everyone around them miserable. You stop that. That matters." Looking back, the whole experience taught me something important about institutions and authority. HOAs exist everywhere in America, governing millions of homes, often with minimal oversight and accountability. They rely on homeowners not questioning their authority, not fighting back, not demanding proof that the rules they enforce are actually valid. Most people, when confronted with a fine or threat from an HOA, will just pay it or comply. It's easier than fighting. It's cheaper than hiring a lawyer. It's less stressful than going to court. The HOAs know this, and some take advantage of it ruthlessly. But sometimes you have to fight. Sometimes you have to stand up and say, no, this isn't right. Prove to me that you have the authority you claim. Sometimes you have to risk the money and stress and time, because the alternative is teaching your daughter that bullies always win. The snow fort melted months ago. But what it represented, a father and daughter having fun on their own property without harming anyone, that's still standing. That's what I fought for, and that's why it mattered. Emma starts second grade next month. She's already planning the snow fort we'll build this winter, bigger and better than before. I told her she can design whatever she wants, and if anyone from the HOA has a problem with it, they can take it up with my lawyer, but I don't think anyone will. Brenda's gone, her reign of terror ended. The neighborhood learned its lesson about unchecked power and unvalidated authority. And I learned that sometimes the most important battles aren't the ones you choose, but the ones that choose you. It's May 17th now, warm and sunny in Winter Haven. The mountains visible from my backyard are still capped with snow, but down here everything's green and alive. Emma's playing in the backyard, building a fort out of cardboard boxes this time. I'm sitting on the deck, drinking coffee and thinking about everything that happened. My final legal bill from Mitchell came to just under $9,000, all of which the HOA reimbursed. The settlement also included their formal acknowledgement that I'd done nothing wrong, that the fines were invalid, and that they regretted the distress caused to me and my family. It's framed in my home office, a reminder that justice is possible even when it seems impossible. Sometimes late at night, I wonder what would have happened if I'd just torn down the snow fort that first day. If I'd complied with Brenda's demands, paid the $500 fine, and moved on with my life, I'd be $9,000 richer in immediate terms, though poorer by the settlement reimbursement. I'd have avoided months of stress and uncertainty. But I also would have taught Emma that the rules always win, even when they're wrong. I would have validated Brenda's abuse of power. I would have allowed an organization with no legal authority to continue extracting money from my neighbors through fear and intimidation. No, tearing down that snow fort would have been the wrong choice. Fighting was the right choice, even though it was hard. Especially because it was hard. The legal reforms that came out of our case extended beyond just Pinecrest Meadows. The Colorado State Legislature took notice of the issues raised by the Denver Post article. By April, 2 representatives had introduced a bill requiring HOAs to provide homeowners with verification of properly recorded CC and RTCS upon request, and imposing penalties for HOAs that attempt to enforce unrecorded restrictions. The bill passed in late May and was signed by the governor in June. Now, every HOA in Colorado has to maintain and provide proof of recorded covenants. They have to disclose to potential buyers whether their CC and RTCS are properly recorded. And homeowners have a clear legal remedy if an HOA tries to enforce invalid restrictions. All because Emma and I built a snow fort and I refused to back down when a bully told me to tear it down. Mitchell calls me occasionally to update me on other cases he's handling. Turns out Pinecrest Meadows wasn't unique. There are HOAs all over Colorado, all over the country, operating on unrecorded or improperly recorded CC and RTCS. Some knew about the problem and kept quiet. Others genuinely didn't know. But in either case, homeowners were being fined, threatened, and in some cases had liens placed on their properties based on restrictions that weren't legally enforceable. The law firm Blackstone and Reed took a reputational hit from the case. Simmons, the attorney who'd handled the litigation, left the firm shortly after the settlement. Word in the legal community was that he'd failed to do basic due diligence before filing suit, relying entirely on Brenda's representations without verifying the foundational documents. It's a cautionary tale for lawyers. Trust but verify, especially when your client is pushing for aggressive action. As for Brenda, I heard through the neighborhood grapevine that she and her husband moved to Arizona. Her criminal conviction meant she had a record, which probably affected her employment prospects. Part of me feels a twinge of sympathy. She went from being HOA president, wielding what she thought was substantial power, to being a convicted criminal who'd lost her home and reputation. That's a hard fall. But then, I remember her face when she marched onto my lawn, the glee with which she threatened $1,000 per day fines, the casual way she tried to destroy my financial security over a pile of snow. I remember the stress that kept me up at night, the fear that I might lose my house, the anguish of trying to protect Emma from adult problems. My sympathy evaporates pretty quickly. Brenda made choices. She chose to enforce rules without verifying their validity. She chose to spend tens of thousands of HOA dollars pursuing a personal vendetta. She chose to embezzle money from the community she was supposed to serve. Those choices had consequences, as they should. The neighborhood barbecue in June was the first one I'd attended in years. Marcus and the new board organized it, a conscious effort to rebuild community spirit after the chaos of the previous months. People came up to me all afternoon, thanking me, sharing their own stories of run-ins with Brenda, expressing relief that things had changed. One elderly woman named Margaret told me she'd been fined $500 because her mailbox had rust spots. She'd paid it because she was on a fixed income and couldn't afford to fight. "That's my grocery money for 2 months," she said, tears in her eyes. I ate rice and beans for weeks because of her. The refund check I got last month, it means the world to me. Stories like that reinforced why the fight mattered. It wasn't about me or my snow fort. It was about every person in every HOA-controlled community who'd been bullied, threatened, or extorted by people abusing positions of trust. It was about accountability and justice, and the idea that nobody, not even an HOA president, is above the law. Emma brought me back to the present, calling from her cardboard fort. "Daddy, come see what I built." I walked over to admire her construction. It was elaborate, multiple boxes connected by cut-out doorways, with windows and a flag on top. She'd used markers to draw stone patterns on the walls, making it look like a medieval castle. "This is amazing, sweetie. You're quite the architect. When winter comes, can we build a snow castle? Even bigger than the fort, absolutely. As big as you want. And nobody can tell us to tear it down. Nobody can tell us to tear it down." She beamed and crawled back into her cardboard creation. I returned to the deck, watching her play, feeling the warm sun on my face. Life was good. The nightmare was over. Justice had prevailed, even though there were moments when it seemed impossible. My phone buzzed with a text from Mitchell. "Thought you'd want to know. Another HOA case just landed in my lap. Unrecorded CC and RTCS again. This one's in Jefferson County. The client mentioned your case as why he decided to fight. You started something, Dave." I smiled and texted back, "Happy to help. Let me know if you need me to talk to the client, share my experience. Will do. Drink sometime. Definitely. I owe you several. I set the phone down and thought about Mitchell's message. Other people were fighting back now, empowered by knowing that HOA authority wasn't absolute, that rules could be challenged, that sometimes the organizations claiming power over your property had no legitimate legal basis for that power. The ripple effects of one snow fort, one stubborn father, one good lawyer, and one corrupt HOA president spread outward in ways I never anticipated. Legal reform, criminal prosecution, class action settlements, and most importantly, a shift in how people thought about HOA authority. Not as something absolute and unchallengeable, but as something conditional, something that had to be verified and proven. The dinner conversation that evening with Emma was typical kid stuff. Her friends at day camp, the book she was reading, her plans for her birthday party next month. Normal, happy, stress-free. This was what I'd fought for, the ability to live our lives without someone like Brenda casting a shadow over everything. As I tucked Emma into bed that night, she asked me something that caught me off guard. "Daddy, were you scared when you were fighting the HOA lady?" I considered lying, saying no, I was never scared. But Emma deserved honesty. "Yes, honey, I was scared. I was worried we might lose our house. I was scared the judge wouldn't believe me. But sometimes you have to do scary things because they're the right things." Like in the stories where the knight fights the dragon, exactly like that. Was Mrs. Whitmore the dragon? I laughed. That's one way to put it. But the dragon lost and we're safe now. Good. She yawned and snuggled into her pillow. "I'm glad you're a brave knight, Daddy." "I'm glad you're my princess. Sleep tight." I closed her door and stood in the hallway for a moment, overwhelmed with gratitude. Gratitude that I'd had the resources to fight. Gratitude for Mitchell's skill and dedication. Gratitude for Linda's courage in coming forward. Gratitude for the judge who saw through the HOA's claims. Gratitude for the reporter who told the story. And gratitude for Emma, whose innocent joy in building a snow fort had sparked a chain of events that changed things for the better. The clock on the wall showed 9:30. Early enough to still be productive. I walked to my home office and pulled up the draft of an article I'd been asked to write for a consumer protection website about HOA oversight and homeowner rights. The editor wanted 1,500 words about warning signs that your HOA might be overstepping its authority. I started typing, drawing on my experience. Warning signs included enforcement of rules without providing copies of recorded CC and RTCS, escalating fines without proper notice, board members making unilateral decisions without votes, lack of financial transparency, and threats of immediate legal action for minor violations. I wrote about the importance of requesting proof of recorded covenants, understanding your state's HOA laws, and not being afraid to consult a lawyer when something felt wrong. The article took me 2 hours to write. When I finished, I read it over and felt satisfied that it would help people. Maybe some homeowner somewhere, facing their own Brenda Whitmore, would read it and realize they didn't have to just accept whatever the HOA claimed. Maybe they'd fight back. Maybe they'd win. I sent the draft to the editor and shut down my computer. The house was quiet, Emma long asleep. I walked out to the back deck one more time, looking up at the stars scattered across the clear Colorado sky. The mountains were dark silhouettes against the lighter darkness of the horizon. Somewhere out there were probably hundreds of other disputes like mine. Homeowners being threatened over trivial matters. HOAs wielding power they might not legally possess. People stressed and scared and unsure what to do. I couldn't fight all those battles, but I'd fought mine, and in doing so, maybe made it a little easier for others to fight theirs. The night air was cool and pleasant. I stood there for several minutes, just breathing and being present. The nightmare months of letters and threats and legal filings and fear felt distant now, like they'd happened to someone else. But they'd happened to me, and I'd gotten through them. We'd gotten through them. Tomorrow I'd go back to work, managing software projects and dealing with deadlines and office politics. Emma would go to day camp, making crafts and playing games. Normal life would continue, but we'd both been changed by what happened. I'd learned that I was stronger and more resilient than I'd thought. Emma had learned that standing up to bullies, even scary ones with official titles, was possible. And somewhere in Arizona, Brenda Whitmore was presumably learning her own lessons about hubris and consequences. I didn't wish her harm, but I didn't regret what happened to her either. She'd made her choices. We all have to live with ours. I went back inside, locked the doors, turned off the lights, and headed to bed. As I lay there waiting for sleep, I thought one more time about that Saturday morning in January when Emma and I had started building a snow fort. If I'd known then what was coming, all the stress and conflict and expense and fear, would I still have refused Brenda's demand to tear it down? The answer came immediately and without doubt. Yes, absolutely yes. 1,000 times yes, because some things are worth fighting for: your home, your dignity, your right to live your life without arbitrary authority interfering, the lessons you teach your children about courage and principle. Justice, and sometimes it really is about a snow fort, a monument to childhood joy constructed from frozen water and imagination, defended at great cost not because of what it was, but because of what it represented: freedom, fun, family. The simple right to build something beautiful and temporary and meaningless, except for the happiness it brought. That was worth fighting for. That would always be worth fighting for. Sleep came easily that night, untroubled by threatening letters or legal deadlines or the specter of financial ruin. The battle was over. We'd won. And when winter came again, Emma and I would build another fort, bigger and better because we could, because nobody could stop us, because we'd proven that even dragons can be slain.